fees and fines have on families and communities. To be clear at the onset, the topic today does not cover restitution or other equitable relief for victims, but focuses costs imposed by the criminal justice agencies upon those who come into contact with the criminal justice system. Just as an aside, let me indicate that I'm very pleased that the Nadler Jackson Lee bill, Victims of Crime Act fix, was signed into law last week. That indicates our commitment to protecting victims all over the nation who have been impacted from crime to human trafficking. And we're glad to see that movement. Here we talk about a different aspect of fines and fees, and I believe it is important to find a solution to the oppression that comes about on individuals who are impoverished. These charges to show up at every level of the criminal justice system. There are fees for traffic detention, phone calls from jail and prison commissary, and fees for pretrial release, such as electronic monitoring, supervision, and parole fees. Some of these fees can be hundreds of dollars a month, which in some places can be imposed before guilt is adjudicated. The United States Department of Justice investigation of Ferguson, Missouri, that followed the tragic and violent shooting of Michael Brown brought the imposition of fines and fees in the justice system to the forefront of our nation's public discourse. In its comprehensive report, the DOJ concluded that the Ferguson Police Department, the municipal court, and the city of all depended on fines and fees to operate. Fines are monetary penalties ordered by a court to be paid by the defendant after arrest that are not restitution or other equitable relief. Many experts argue, and I believe factually, that the fees charged by Ferguson, like those levied elsewhere in the United States, helped entrench poverty, exacerbate racial disparities, undermining public safety, diminishing trust in the judicial system, and as well, trapping people in cycles of poverty and punishment. After arrest, most judicial systems require to have people pay fines and fees. These fees are for minor traffic and municipal code violations, misdemeanors, and some low-lying felonies, and as well, and are considered resources, unfortunately, for funding the government. That is of great concern to all of us, and I would make the argument that as we proceed, we'll find out the basis of all this. To be clear at the onset, the topic today does not cover restitution, as I've already said. What the imposition of fines and fees have done is create a two-tier system of justice. Those that can afford to immediately pay their court debt can exit the justice debt system after the underlying matter is resolved. Americans without the means, by contrast, may be quickly trapped in what can be for many a spiral of mounting debt long after their case has been settled. The total scope of the court-imposed fees is astounding. By some estimates, criminal justice debt in this country will exceed $27 billion without reliable data. The exact amount is unknown and likely unknowable, but it still appears to be a staggering level. On a personal level, the harm caused by court-ordered debt can be grave. I remember going to the region that our member represents after the shooting of Michael Brown. Our vice chair comes from that area and has spoken often about it, Vice Chair Congresswoman Bush. I remember going to that area and meeting women who, head of household, who unfortunately were caught up in the fines and fees, lost their jobs, and were not able to take care of their family. Some finding found disturbingly that 83% of those surveyed gave up necessities like rent, food, medical bills, car payments, and child support in order to pay their court debt. Communities are harmed as well. The same study found that 38% of respondents admitted to having committed at least one crime to pay off their court debt. About 20% of those whose only previous offenses were traffic violations admitted to committing more serious offenses, included felonies, to pay off their traffic tickets. This means that levying fines and fees take food out of the mouth of those who can't afford to pay them and decreases public safety by perversely incentivizing further criminal behavior. The harm doesn't stop there. The deleterious impact of the imposition of fees and fines is most acutely felt by juveniles. Youth who have interactions with the juvenile justice system often are required to pay fines and fees. Juvenile fees, like adult fines, and fees include juvenile detention fees, fees for drug testing, and charges for physical and mental health treatment. The practice of passing fees imposed on juveniles to their parents or guardian is too common and has the effect of weighing down an entire family, and particularly an impoverished family. The woman that I met in the Ferguson community had been in jail because she was not able to pay the fines and fees. When juveniles fail to pay fines and fees, the debt may also follow them into adulthood, putting them a step behind their peers even before they've had a chance to begin their adult lives. Weighing down youth with debt at the start of their adult lives undermines the very goal of our juvenile justice system, rehabilitation. I applaud the efforts in the states to eliminate the imposition of fees and fines, but more must be done to remove these barriers to youth rehabilitation. That is why we're holding this hearing. More must be done. One of the most troubling trends in the collection of fees and fines is the outsourcing of rehabilitative services to entities that then charge fees for their services. This is a circle that one does not want to be in. These fees, which often become collectible by court order or contract, are sometimes levied without the supervision of a judge. This type of arraignment can elevate private supervision companies to the position of determining not only whether a supervised violate the terms of their supervision, but whether a fine should be imposed, and basically creating more debt. I'm gravely concerned that this type of arrangement is both corrosive to public trust in the criminal justice system and that it incentivizes private companies to violate supervisees simply to impose or improve their bottom line. That is absolutely ridiculous and, of course, tragic. What's particularly troubling is the report's finding that private companies charge many fees for profit. Evidence shows how levying court-imposed fees and fines is not only harmful for those who can't afford them, but it's a bad deal for the taxpayer. A 2019 report by the Brennan Center for Justice revealed that the counties studied, including those in my home state of Texas, spent more than 41 cents of every dollar collected from fees and fines on related in-court hearings and jail costs, meaning that for every dollar imposed, only 59% made it into state coffers. The harm these fees and fines cause does not outweigh the fraction of the charges that are ultimately collected. Our criminal justice resources should be used on other high-priority issues like preventing and responding to violent crime and reducing recidivism. As we discuss this pressing issue, I hope to work across party lines to serve our constituents and communities better. Already, state and local governments have recognized the terrible cycle of harm that justice-related fees and fines can impose and have begun enacting essential reforms. Groups across the political spectrum have expressed support for reducing and eliminating the use of fines and fees. That is why I believe this common ground is good for a discussion for this committee, where we will be working in a bipartisan manner to solve this problem and to help Americans overcome the detours in their life, but to do it under the light of justice. I look forward to working with my colleagues to address this issue. It is now my pleasure to recognize the ranking member of the subcommittee, the gentleman from Arizona,